Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who geek out on this channel all the time, number one, thank you very much. But number two, you will know that I have talked frequently about this all-out war on our Second Amendment rights, and it is a war that is being fought on all fronts. They are coming to us from every direction, and they will stop at nothing to disarm you. And we see that it's a lot more than the usual suspects. It's not just the federal government and the state legislatures. Oh, no. It's private industry, it's mainstream media, it's electronic media, it's all sorts of other industries that are working in concert with the government to disarm you. Now, listen, they may have come up with the best way of disarming you, and the reason it might be the best way is, well, because I think the courts are going to be complicit in it. So today, let's get you all educated about something that I think is really scary and we need to be aware of. So let's spend a few minutes and let's talk about the most effective way they will disarm you. Okay, America, what we're talking about is statutory waiting periods. There has been multiple challenges to newly enacted statutory waiting periods, and none of them seem to be going anywhere. Now, on a side note, what statutory waiting periods do, even though they're designed to save lives, is oftentimes they cost lives, particularly those of abused women, because women will go, once they're in these horrific, very dangerous situations, they will go to FFLs, try to obtain a firearm to protect themselves, and then they're told, well, their life is not worth protecting right now. Maybe it will be in 7 or 10 days. And I cannot tell you how many times violent activity occurs during that statutory waiting period, which does not work out very well for the victim. Now, the problem for those that are promoting waiting periods is that we have a new test for analyzing the constitutionality of gun control legislation. It's called the Bruin test. And what the Bruin test basically says is, hey, listen, we're going to analyze the constitutionality of gun control legislation. The first question we're going to ask is, does the plain text of the Second Amendment actually cover the activity? If the answer is yes, then the government must prove through historical analogs that we as a society have accepted these sorts of restrictions. Now, when it comes to statutory waiting periods, this is a much more recent phenomenon. In fact, if you get really creative and looking back in the history books, the soonest you'll find a statutory waiting period is 1920, well after the ratification of the Second Amendment or the 14th Amendment. So the problem for those that are promoting these statutory waiting periods is pretty simple. There is no history to back it up. So what the courts are doing, and I have seen this over and over and over, and we will give you some examples. The court is basically saying, hey, the Second Amendment's not even implicated here. And you go, wait, how is the Second Amendment not implicated? Well, the court is ruling that the Second Amendment might protect the right to keep and bear arms, but it does not in any way, shape, or form protect the right to accumulate a firearm. The most recent example comes from the state of New Mexico, who recently passed a 7-day statutory waiting period. When challenged, and the court upheld that statutory waiting period, the court ruled that the waiting period does not constrain in any way, shape, or form the right to keep and bear an arm. And while it might have a minimal burden on the right to acquire a firearm, that's an ancillary right, so it's really not that important. The court also ruled that a statute from 1920 would actually serve as the proper historical analog to justify the existence of New Mexico's new waiting periods. Now, we all know, because you guys geek out on this channel, that there is a mountain of case law that says the ancillary rights necessary to exercise the core right found in the Second Amendment are also equally protected. Apparently, many of these state courts have not gotten that memo, because the example I gave you from New Mexico, well, it's not standing alone. Take, for example, New York City. New York City has this goofy little rule where you can only purchase one handgun every 90 days. When challenged in the case of Knight versus New York City, what did the court rule? The question thus becomes whether a waiting period before the purchase of a second handgun is conduct covered by the Second Amendment. It is not. But you see, that's just the first of a couple of examples, because there are more. Take, for example, Vermont's waiting period. Yeah, that was subject to a challenge earlier this year as well in the matter of Vermont Federation of Sportsmen's Club versus Birmingham. And how did the court in July of this year rule? Well, as follows. The court finds the relevant conduct, acquiring a firearm through a commercial transaction on demand, is not covered by the plain text of the Second Amendment. Plaintiffs may keep and bear arms without immediately acquiring them. I'll give you another example. Colorado now has a statutory waiting period. When the Rocky Mountain Gun Owners Association tried to file a challenge to that, how did the court rule? Well, it ruled as follows. From the reading of the plain text, it is clear the relevant conduct impacted by the waiting period, the receipt of a paid-for firearm without delay, is not covered. To keep, under the definition provided in Heller, meant to retain an object one already possessed. It did not mean to receive a newly paid-for item, and it certainly did not mean to receive that item without delay. Likewise, having weapons indicates the weapons are already in one's possession, not that one is receiving them. But it doesn't stop there. In a challenge again earlier this year to Pennsylvania's statutory waiting period in the case of United States v. King, how did the court rule there? Even if the court assumed that there is an implicit right in the Second Amendment to buy and sell firearms in order to keep and bear arms, that is not the same thing as a right to buy and sell firearms as a regular course of trade or business with the principal objective of livelihood and profit through the repetitive purchase and resale of firearms. In other words, the Second Amendment does not protect the commercial dealing of firearms. That last sentence should be very scary to all of you, because if the Second Amendment does not protect the commercial dealing of firearms, what stops a state like California, Illinois, New Jersey, New York, the usual suspects, from just passing legislation to ban gun sales altogether in the state? And here's what's more nefarious about it, because while the state legislatures are doing this, the governors in most of these states, well, they know better. Don't believe me? Let's go back to the pandemic. Take, for example, my state. Our governor here kept his emergency powers for 975 days. Did he ever close down the gun stores? No, actually, he didn't. They were considered an essential business. And when you look around at all of the other states, California, Oregon, Illinois, New York, New Jersey, Maryland, all of the states that had some of the most ridiculous COVID lockdown rules, yeah, even in those situations, gun stores were not shut down. Now, the governors thought about it. Some of the governors even tried it, but they got nowhere. Why is that? Because it is an essential business. How can the FFL industry be an essential business and yet you have no constitutional right to acquire a firearm? And the absurdity of waiting periods can really be summed up this way. Do you have to wait before you go to church? Do you have to wait before you buy a Bible? You buy a Bible today, do you got to wait 10 days before you can actually take receipt of it? Do you have a 30-day waiting period before you're free from unreasonable searches and seizures by the government? Do you have a 60-day waiting period before you don't have to incriminate yourself? Yeah, you have a right to counsel, but do you have to go through a 14-day waiting period before you get an attorney? Of course not. This goes to show the absurdity of statutory waiting periods. It also goes to show and proof definitively that the Second Amendment truly is the disfavored right. Listen, America, these statutory waiting periods are just the tip of the iceberg. If they are allowed to stand, you will see state legislatures erode continuously at your ability to accumulate firearms and ammunition, thus precluding you any possibility of ever exercising your God-given, inalienable Second Amendment right. Listen, if you guys got any more questions about this or anything else related to what's left of our Second Amendment rights, y'all should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got an idea for a video we should be doing here. If you do, go ahead and click on that link right there. Or maybe you just want to subscribe to our monthly newsletter. The ability to do so is all laid out for you down below in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.